Good evening, everyone. In this lecture, we will know about Limitation Act. Limitation Act is of 1963. The important dates are 1/1/1964, the date when it came into effect, and the second date is 5/10/1963, which I do not know why it is mentioned in the Limitation Act. When you open it, it is mentioned over there 5/10/1963. Let me open it. Yes, 5/10/1963. So, what is the Limitation Act? Limitation Act is a statue of peace, repose and justice. Peace, शांति बनी रहे. Litigation होगी नहीं तो शांति बनी रहेगी. When there is no right to file the litigation, no litigation will be filed, there will be peace in the society. Repose, peace को repose. Let's say it's been filed, suit हो गया, अपील का टाइम बार हो गया, अब पीस रीपोज हो गई, पीस दोबारा से आ गई, क्योंकि अब अपील तो डाल नहीं सकते आप. सूट में तो यू कंटेस्टेड, डिस्टर्ब द पीस अ बिट, ऑफ कोर्स ऑफ बोथ द पार्टीज डिपेंड, इट इज अ मैटर ऑफ पर्सोनम और रेम. एंड जस्टिस, लॉन्ग delayed claim are more of a cruelty than justice on the defendant especially. So John Wood, you must have been seen, I've written over here, he has defined the Limitation Act as the controversies should be fixed within a limited period of time, and it is then justified if they are treated as immortal while human life is mortal. And a very important case is by Privy Council, Harinath versus Mathur. It says the intention of limitation law is not to give the right where there is none, not to take away the right where there is none, where there is one, sorry, not to give the right where there is none, not to take away the right where there is one, but to lay down a time limit within which this rights can be enforced. So when Limitation Act comes into force, when there is cause of action. What is cause of action? Bundle of essential fact necessary for the plaintiff to prove in order to entitle himself for the relief. Bundle of essential facts. It has nothing to do with the relief he is demanding, and nothing to do with the defense of the defendant. So this is what cause of action is. So Limitation Act comes into play when there is cause of action, when there is competent plaintiff. Section 16 Limitation Act. Competent means legally competent. Indian Majority Act 1875 की लाइट में competent. Limitation Act comes into play when there is cause of action, when there is competent plaintiff, and there is defendant. Defendant को competent होना जरूरी नहीं है. However, not the one who is in the womb, he must have come into existence. And Limitation Act comes into play. Limitation शुरू हो जाती है. For suit appeal application, तीन ही चीज़ों से डील करता है. इनफैक्ट तीन चीज़ें ही काफ़ी हैं टू कवर एवरीथिंग. सो इसमें 5 पार्ट्स हैं, 32 सेक्शंस हैं, एंड 1 शेड्यूल है जिसकी 3 डिविजन्स हैं. सूट अपील एप्लीकेशन, ये तो बेयर एक्ट हो गया जो आप पढ़ सकते हैं. वी शैल गो थ्रू द सेक्शंस, एंड अभी तो पढ़ा हुआ है. सेक्शंस को शुरू करने से पहले का जो मटेरियल होता है, दैट ये एप्लीकेबल किन प्रोसीडिंग्स पे है. It applies to the civil proceedings, and it does not apply, जैसा कि सेक्शन 28 भी एक्सप्रेसली लिखता है, स्पेशल लॉ लोकल लॉ में अगर अपना प्रोसीजर दे रखा है तो फिर अप्लाई नहीं होगा. पर्सनल लॉ, मैरिज, डाइवोर्स, रेस्ट्रिक्शन कॉन्जुगल राइट्स, इलेक्शन पिटीशन, रिप्रेजेंटेशन ऑफ पीपल एक्ट है, हाई कोर्ट में फाइल होएगी. क्यों? लिमिटेशन एक्ट, उसमें दे भी रखी हुई होगी, दैट इज व्हाई it is being excluded in the interpretations, not expressly in the bare act. So objective limitation act is long dormant claim have more of a cruelty than justice in them. It is unfair for the defendant to have a claim hanging over him for undue long period, indefinite period. Interest publicate sit finis litium. It is in interest of the state that there should be end to litigation. Vigilantibus non dormantibus juris subveniens. Law is for those who are vigilant for their rights, but not for those who sleep over them. Defendant might have lost evidence to support his claim. Unlimited perpetual threat of litigation creates insecurity, uncertainty. ये ऑब्जेक्ट्स हैं, आप पॉज करके फिर से सुन सकते हैं. दिस इज द मोस्ट कॉम्प्रिहेंसिव ऑफ द ऑब्जेक्ट्स ऑफ लिमिटेशन एक्ट. इसके अलावा नहीं है. लिमिटेशन एक्ट डजंट अप्लाई टू आर्टिकल्स 32 to 6 proceedings because constitutional rights are held in Rajmata Vijay Raje Scindia versus State of UP. Vijay Raje Scindia versus UP. So, how the provisions of Limitation Act to be interpreted? Is this a penal provision? I say yes. The reason of this yes is it is penal in its application. It is not penal in its interpretation, or it is not penal in its literary words meanings. It is penal in its application. It is a negative law. Right लेके जा रहा है, दे नहीं रहा. Inflexible. This is the feature of Limitation Act. It is inflexible. Can you claim the right of sufficient cause? Sufficient cause you have put forward the court of law. Do you have a right to ask the court, sir, since we have provided you the sufficient cause, give us that limitation में हमें छूट दे दी जाए, just like हमारी delayed proceedings को accept कर लिया जाए. Even after putting forward the sufficient cause, you have no right to be heard. This is why it is inflexible law. So हम आगे चलते हैं. तो स्टार्ट इसी से हुआ था. ये जो लास्ट वाला आर्ग्यूमेंट था कि हाउ दिस लॉ इज टू बी इंटरप्रेटेड. दिस लॉ इज टू बी इंटरप्रेटेड स्ट्रिक्टली बिकॉज दिस इज अ penal in its application, inflexible. Strict grammatical meaning to be given to the words of this statute, and any equitable consideration is out of place. So what does section 3 says? Section 3 lays down the rule. Section 4 to 24 lays down the exceptions. 3 says suit instituted, proceeding instituted, application made, appeal filed, if it is barred by limitation, not is the duty of the court. पहली तो ड्यूटी कोर्ट की है कि उसको पर से ही डिसमिस कर दे इनिशियल स्टेज पे. अब दो चीजें सबसे इंपॉर्टेंट आती हैं, सेट ऑफ और काउंटर क्लेम. Set off is seen to be taken to be instituted when the suit is instituted, and counterclaim is taken to be instituted when it is actually prohibited with the court of law. This is what section 3 says, very clear. So section 3 ने क्या किया? रूल लेट डाउन किया, प्लस कोर्ट की ड्यूटी लेट डाउन की, और प्लस कह दिया 4 to 24 hours its exceptions. अगर आपका केस 4 to 24 में फॉल करता है तो 3 का रूल अप्लाई नहीं होगा, उस पर्टिकुलर सेक्शन के प्रोविजंस अप्लाई हो जाएंगे. सो क्या कोर्ट के सियो मोटो एक्शंस पे लिमिटेशन लगता है? सियो मोटो actions of court sorry, suo motu action of court and limitation act. The answer is no. Dhan Singh versus Basant Singh. It is confined to the litigants. Section 3, Limitation Act, confined to the litigants, not to the courts. Secondly, there is no limitation to correct one's own mistake. अब मैं आपको lecture दे रहा हूँ. I'm trying to be very correct and as far as very precise in my wordings. But if at some point I go wrong, and आप मुझे point out नहीं करते, जो कि आज तक तो आपने करा नहीं point out, and मैं खुद को खुद ही introspect करके ढूंढता हूँ that at that point I stated some wrong facts. I corrected it. Limitation लगेगा? No. There's no limitation on the courts while taking suo motu action. There is no limitation to correct one's own mistake. We go to section number 4. The rules of elementary justice. Law doesn't ask you to do the impossible. Court band hai. The court is said to be closed when in its ordinary working hour it is not working. 10 से 4:30 टाइम होता है कोर्ट का. 4:25 पे जज जी उठ गए, कोर्ट बंद हो गई. 5 मिनट आपको बेनिफिट मिलेगा सेक्शन 4 का. It's a rule of elementary justice. Lacks non-cogit ad impossibility. A law doesn't ask you to do the impossible. And actus cruae neminem gravamit. Act of court should prejudice no man. As simple as that. Rule of elementary justice. However, the court should be the correct court, not like wrong court में जा रहे हैं आप. अब wrong court में जा रहे हैं तो फिर section 14 आपको देखना पड़ेगा, जो हम थोड़ी देर में पढ़ेंगे. Right court, फिर benefit मिलेगा आपको. So section 5 onwards हम थोड़ी देर में पढ़ते हैं. Thank you for now.